Ikwe Mendugo Linda. You have 3 minutes.
Ok. Honorable commissaire, monsieur le modérateur, madame et messieurs les panélistes, la délégation camerounaise adresse ses félicitations de ce panel et la conduite des échanges sur les questions essentielles que constituent la protection sociale et l'accès aux services sociaux. La délégation voudrait d'ores et déjà indiquer que le gouvernement de la République du Cameroun a entamé les procédures internes en vue de la signature et de la ratification du protocole à la Charte africaine relatif aux citoyens, à la protection sociale et à la sécurité sociale. La finalisation de ces procédures devrait contribuer au renforcement du dispositif législatif et réglementaire en vigueur, qui comprend notamment les textes ci-après. La loi du 12 juin 1967 instituant le cadre des prestations familiales, la loi du 14 juillet 1980 portant réparation et prévention des accidents de travail et des maladies professionnelles, le décret du 19 août 1974 fixant les modalités d'application de la loi de 1969 instituant un régime d'assurance, pension de vieillesse, d'invalidité et de décès, le décret du 13 août 2014 fixant les conditions et modalités de prise en charge des assurés volontaires et le décret du 15 février 2016 fixant les taux de cotisation sociale et plafond des rémunérations applicables dans les branches des prestations. La mise en œuvre effective de ces textes fait intervenir un certain nombre d'acteurs parmi lesquels figure la Caisse nationale de prévoyance sociale. Les différents services fournis par cette institution sont disponibles en ligne via le site www.cnps.cm. Outre ces textes, le Cameroun a ratifié par décret du 19 juillet 2022 le traité révisé de la Conférence internationale de la prévoyance sociale, en abrégé CIPRES. Enfin, la délégation voudrait indiquer que depuis le 12 avril 2023, la première phase de la couverture santé universelle est opérationnelle en faveur des femmes enceintes, des enfants de 0 à 5 ans, des personnes sous dialyse, des personnes vivant avec le VIH-Sida et des personnes atteintes de tuberculose et d'onchocercose. Je vous remercie de votre aimable attention.
Thank you very much. We will now hear from the representative from one of the AU organs, Mr. Francis Luhanya. Mr. Francis Luhanya, you have 3 minutes. He's not here. Very well. We will now proceed to a statement from one of the NGOs. We only have one which registered, which is the Global Initiative for Economic, Social and Cultural Rights, represented by Ms. Rosaline Onyango. Ms. Onyango, you have 3 minutes.
Obligations under the African Charter on Human and People Rights in the context of private provision of social services. In this bearing comments, the African Commission has led the way for other regional human rights bodies and the United Nations for providing the most comprehensive interpretation of state obligations under human rights law regarding social services and their inclusive connections to the attainment of rights, especially economic, social, and cultural rights. We welcome in particular the general comment's emphasis on the non-commercial and public nature of social services. We commend the elaborate to support resource mobilization, budget allocation, and spending to fund the provision of social services. One of the effective means of mobilizing resources is through fair and progressive taxation. Research assistance, tax rates, riders, social services such as health, education, and social protection mechanisms. By disseminating the General Comment 7, states can be aware of their duty to monitor and regulate private actors providing social services and hold them accountable. Furthermore, it could encourage member states to ratify the protocol to the African Charter on Human and People's Rights and Social Protection in Africa. NHRIs can advise states on how to incorporate the provisions of General Comment 7 in their laws and policies governing the delivery of social services. Civil societies can raise awareness and understanding of the human rights implications of the private provision of social services and how it affects social protection while encouraging its use in public interest litigation at the national level. Additionally, General Comment 7 can also be utilized in the United States and operating in Africa and Asia. It has also been reported that the World Bank's International Finance Corporation, which held an equity stake in Bridge International Academies between 2018 and 2022, turned a blind eye to the abuse. 32 civil society organizations have demanded accountability in response to the child sexual abuse report in a joint statement that has been attached. As a reminder, the Commission expressed concerns about the lack of monitoring and effective regulation of Bridge International Academies in its 2016 concluding observation on the 8th to 11th period. We also call on state parties to strengthen the monitoring and accountability mechanisms regarding private actors' provision of social services, including education and healthcare services. Thank you.
Thank you very much. In reverse order in which the panelists delivered their statements, I'll ask Alana to give us closing remarks. 1 minute.
Thank you, Chair. I want to also remind states that as they deal with where they put the money, that before you begin putting your public finances in these public-private partnerships or supporting some of the private actors, make sure your systems are clear, your public health, public education, social protection systems. You have devoted maximum available resources, because it doesn't make sense. I was listening to a statement from the NGO to put some money in private entities when your people are lacking drugs in your public health hospitals. But to conclude, like I said before, we want to continue this discussion as NGOs and continue to raise awareness. We're having an event at Dululuti Hall in Serengeti Wing at 3rd floor at lunch PM, just to talk about the Africa Manifesto on Public Services. It was convened by many Africans who are in this room when we sat and reflected, and it very much echoes the ideals covered in these instruments, and it shows that there is a demand among Africans. So we hope that the states will ratify this instrument, the optional protocol, and implement both of them so we can have the Africa we want. Thank you.
Thank you very much, Chair, and thank you for the comments. I think, very briefly, I think for states as immediate action, perhaps to undertake a survey, as perhaps Cameroon has given us a sense of how they looked at the existing legislation, decrees, regulatory framework in terms of social provision of social security. That, I think, is a starting point to see, the entry point into ratification of the social protection protocol. And I think the same should be done in terms of private actors, so that the state conducts a comprehensive study or survey to see what the state is. And I think those two kind of surveys will lead almost automatically into ratification. And may I, Chair, just say that as much as we focused here on the protocol on social protection and social assistance, which is very important, perhaps we should see it as a triad. So while states are looking at ratification of this protocol, let us look at the older persons and the persons with disabilities protocols, which are on any one of the three. Thank you, Chair.
Thank you, Mr. Thomas.
Okay, thank you. Okay, maybe just I need to reiterate that the need for an advocacy campaign. Normally, governments are reluctant to add more obligations to themselves, but as indicated in my presentation, that these obligations are already enshrined not only in the African Charter, but also the International Covenant on Economic, Social, and Cultural Rights, and even in the domestic legislations. I didn't see a country which doesn't have any obligation to provide the allowance for the people and education. So the issue is not very complicated, given that maybe just to do the myth busting to eliminate the misconceptions about the protocol, and I think it's not going to be a difficult task. Thank you.
Thank you very much. Your Excellencies, distinguished delegates, our panel discussion is now ended. But before we leave the high table, I would like you to join me in applauding the panelists in the manner that they dealt with the topics that were assigned to them.
Thank you very much, Honorable Commissioner Mandenga and all the panelists for raising awareness on what is relating to ratification of the Social Protection Protocol and General Comment Number 7 on state obligations. I think we want to also commend them also for being very timely in terms of skipping to the time and ensuring that we gain some time because we started a bit late. Thank you very much, and I think I will call upon you to just give them another round of applause before we continue. Thank you. We now move back to item 7, which is activity reports of members of the Commission and special mechanisms. And we will have the, is it? Which one is it? We'll have the Special Rapporteur on Freedom of Expression and Access to Information in Africa, Honorable Commissioner Gracia Topsy-Sono. You have the floor. You have 15 minutes to do your presentation, and then we'll give some time for the participants to intervene. We have people who have registered, and we'll deal with that when we get to that point. Thank you.
Thank you, Vice Chair. Good morning, Vice Chair. Good morning, Commissioners. Good morning, distinguished delegates, ladies and gentlemen. This report is presented in accordance with Rules 25(3) and 64 of the Rules of Procedure 2020 of the African Commission on Human and People's Rights and covers activities carried out during the intercession period between May to October 2023. The report is structured as follows. Part 1 covers activities undertaken in my capacity as a member of the Commission and as a member of a working group on the Working Group of Death Penalty, Extrajudicial, Summary or Arbitrary Killings and Enforced Disappearances in Africa. The Part 2 covers activities undertaken in my capacity as a Special Rapporteur on Freedom of Expression and Access to Information in Africa. Part 3 covers the report on interventions issued in response to human rights violations. Part 4 comments on the commemoration of the 10th anniversary of a model law on access to information for Africa. And Part 5 is the conclusion and recommendations of the report. So I start with Part 1, activities undertaken in my capacity as a member of the Commission. From the 19th of July to the 2nd of August 2023, I participated in the Commission's 76th Ordinary Private Session, which was held virtually to consider communications, adopt concluding observations on state periodic reports, the midterm review of the ACHPR 2021-2025 strategic plan, country and thematic resolutions, in addition to considering a number of reports. Activities undertaken in my capacity as a member of a working group on the death penalty. On the 15th of June 2023, in my capacity as a member of a working group on the death penalty, I participated in a virtual induction workshop for the new expert members on the working group who were appointed during the 73rd Ordinary Session held in November 2022. This provided the opportunity to introduce the new members to the Commission's work, methods and priorities, and enable them to fulfill their mandate. The overall objective of the workshop was to discuss the working group's short and medium-term priorities, in addition to reviewing and adopting its 2023 annual work plan. Part 2 deals with my activities as a Special Rapporteur. From 31st of May to the 2nd of June 2023, I attended the Conference on Information and Communication Rights in Africa, held in Windhoek, Namibia. The meeting was convened by Fest Media Africa. The conference brought together access to information, digital rights and human rights activists, media workers, amongst others, from across Africa, in order to discuss the state of freedom of expression and access to information in Africa. The meeting also provided a useful opportunity to popularize the Commission's soft law instruments adopted to give effect to Article 9 of the African Charter, including the Declaration of Principles on Freedom of Expression and Access to Information in Africa. On the 18th of June 2023, I was invited to deliver a statement during the launch of the Media Associations for Self-Regulation, MASR, an initiative of a Zambian media fraternity. I intervened virtually. In my statement, I extended my congratulations for the establishment of the Media Associations for Self-Regulation, in addition to the authorization of Media Ethics Complaints Commission and the development of a Media Code of Ethics. I noted that this development marks an achievement of one of the targets of the Windhoek Outcome document prepared at the Regional Conference on Information and Communication Rights, in which participants committed to, and I quote, develop and enhance self-regulatory mechanisms that uphold professional standards and addresses issues of media accountability and transparency, unquote. On the 15th of September 2023, I participated virtually in the East and Southern Africa Regional Governance Forum and Democracy Day Roundtable. During this meeting, I participated in a panel discussion on the theme, Reimaging Democratization in the Digitalization Age, during which my intervention focused on the following: mapping the opportunities versus the risk of digitalization to democracy in Africa, artificial intelligence, and the future of democracy in Africa, striking the balance between national security versus citizens' online rights. Finally, how African states can leverage the opportunities of digitalization to enhance meaningful youth political participation and representation whilst protecting against risk. On the 22nd of September 2023, I participated in a virtual interview conducted by the University of Birmingham as a contribution for the publication on regulating digital media in Africa. My intervention provided an overview of the online media regulatory landscape in Africa, censorship policies, the role of the AU in regulatory policies, in addition to my views on the continental approach and policy implementation. On the 26th of September 2023, I gave a keynote address and participated in a webinar on the launch of reports on proactive disclosure of information and elections in Africa, convened by the Center for Human Rights of the University of Pretoria. The reports which were launched assess the compliance of a number of state parties, namely Ghana, Kenya, Uganda, and the Gambia, with the African Commission's guidelines on access to information and elections in Africa during the electoral periods. The reports examine the proactive disclosure of credible election-related information by election management bodies, appointing authorities, law enforcement agencies, political parties and candidates, media as well as regulatory bodies, election observers and civil society as envisaged under the guidelines. On the 28th of September 2023, in commemoration of the International Day for Universal Access to Information, I gave an address via recording to the National Forum on Access to Information. This commemoration was held in Mogadishu, Somalia, and was convened by the National Union of Somali Journalists. This commemoration provided an opportunity to advocate for the enactment of access to information law in Somalia, in addition to facilitating constructive dialogue on how to effectively promote and protect this right. Part 3 deals with a report on interventions issued in response to human rights violations. So on the 2nd of August 2023, in my capacity as the Commissioner Rapporteur for Human Rights Situation in the Republic of Zambia, I participated in a joint letter of commendation in conjunction with the Special Rapporteur on the Rights of Women in Africa, which was conveyed to His Excellency the President of the Republic of Zambia, following the government's approval of a publication and introduction in Parliament of a Marriage Amendment Bill 2023. The letter commended inter alia the raising of the age of marriage from 16 to 19 years, thereby contributing to eradication of child marriage. This amendment of the Marriage Act, which raises the minimum age to 19, gives effect to Article 3 of the African Charter on Human and People's Rights, in addition to Articles 5 and 6 of the Protocol to the African Charter on Human and People's Rights and the Rights of Women in Africa. On the 16th of August 2023, in my capacity as the Commissioner Rapporteur for the Human Rights Situation in the Republic of Zambia, I participated in a joint letter of urgent appeal in conjunction with the chairperson of the Working Group on the Rights of Older People and People with Disabilities in Africa and the chairperson of the Committee for the Prevention of Torture in Africa, which was conveyed to His Excellency the President of the Republic of Zambia regarding the situation of chronic ill health, which subjects him to the constant violation of his rights to dignity, protection against unjustified discrimination, freedom of movement, and numerous other rights, such as the right to justice, equal access to public services, and other economic, social, and cultural rights. The alleged violation is also an indispensable tool which empowers people to demand accountability from governments and to participate in public life. The statement commended the state parties which have adopted national laws to ensure promotion and protection of the right to access to information, and further called on states to establish and mandate effective oversight mechanisms in order to popularizing the laws to ensure awareness on the right of access to information. Part 4 of my report goes on the commemoration of the 10th anniversary of the Model Law on Access to Information for Africa. So the Model Law on Access to Information in Africa, a soft law document adopted by the Commission in 2013, so in 2023 marks the 10th anniversary of its adoption. In view of this milestone, the following is a brief elaboration of the process of its elaboration, in addition to its contribution to the access to information landscape on the African continent. The right to information enshrined in Article 9.1 of the African Charter is a fundamental human right necessary for the enjoyment of all other human rights. The right to seek and receive information is essential for a transparent and accountable government. Prior to the establishment of a special mechanism on freedom of expression and access to information, the Commission adopted the Declaration of Principles on the Freedom of Expression in Africa during its 32nd Ordinary Session in October 2002. The adoption of the declaration was a landmark event in that Africa now had a regional standard which supplemented with the limited scope of the right to freedom of expression as guaranteed by Article 9 of the African Charter. Whereas the declaration focused on principles related to freedom of expression, including principles relating to the media, Article 4, titled Freedom of Information, elaborated 6 principles on access to information, which for the next 10 years set the regional standard for the promotion and protection of the right to access to information in Africa. Following the adoption of the declaration, the Commission decided to establish a mechanism to oversee the implementation of the declaration and, by extension, Article 9 of the African Charter. This was implemented in the form of a designation of a focal person within the Commission for this purpose. In 2004, the focal person on freedom of expression was transformed into a special rapporteur on freedom of expression. The mandate of a special rapporteur was expanded to include the right to access to information via a resolution adopted during the 42nd Ordinary Session held in November 2007. This expansion fully facilitated efforts to address issues of access to information as a fully fledged right in itself, separate and distinct from the right to freedom of expression in Africa. In the activity report presented during the 44th Ordinary Session held in November 2008, the former Special Rapporteur noted that, and I quote, "There is an urgent need for the formulation of a model law or guidelines on access to information on the continent. to assist countries to draft laws which comply with international and regional standards and at the same time are simple, affordable, and easy to implement. End of quote. Accordingly, in response to the glaring need for the development of normative standards to guide state parties in the development and adoption of access to information laws in fulfillment of their obligations under the African Charter, the Commission decided to begin the process of drafting a model access to information legislation for Africa, mandated by a resolution on securing the effective realization of access to information in Africa, adopted during the 48th ordinary session held in November 2010. This resolution was the beginning of a nearly 2.5-year-long legal process for development of model law involving numerous experts on the continent. Furthermore, continent-wide consultations with stakeholders took place for each sub-region between June 2011 and June 2012, in addition to a public call for comments on the draft model law issued by the Commission. The model law was subsequently adopted during the Commission's 13th extraordinary session and launched during the 53rd ordinary session of the Commission in April 2013. As stated in its preface, the model law seeks to achieve the following. Firstly, it aims to ensure that legislative drafters and policymakers address all issues relevant to the African context in the adoption or review of access to information legislation, in addition to serving as a benchmark for measuring compliance with regional and international human rights standards for access to information. Secondly, it aims to serve as a tool for access to information advocates across Africa, to stimulate public debate on access to information at the national level, in addition to raising awareness of the cross-cutting nature of the right of access to information and the potential of this right to address issues such as poor service delivery, underdevelopment, and the effective functioning of the justice system. Thirdly, it also seeks to build upon best practices in terms of legislative drafting that have emanated from the adoption and implementation of existing laws in Africa and around the world. Lastly, it seeks to reinforce a commonality of approach on access to information in Africa, while at the same time leaving room for state parties to adopt the model law provisions on the basis of their own legal systems and constitutional frameworks. In my view, it goes without saying that there is a direct correlation between the adoption of a model law and the proliferation of national legislation on access to information. When the model law project started, only 5 countries on the continent had adopted access to information laws. However, since the adoption and the development of a model law, most countries have adopted access to information laws. As at October 2023, 27 countries have adopted such laws, including Angola, Benin, Burkina Faso, Côte d'Ivoire, Ethiopia, the Gambia, Ghana, Guinea, Kenya, Liberia, Malawi, Morocco, Mozambique, Namibia, Nigeria, Niger, Rwanda, Seychelles, South Africa, South Sudan, Sierra Leone, Sudan, Tanzania, Togo, Tunisia, Uganda, and Zimbabwe. This represents about half of the 55 African countries. The influence of a model law can be seen in that several states actively engage with a special mechanism on freedom of expression and access to information during the elaboration of their respective legislation on the right to access to information. Furthermore, the special mechanism has consistently commended state parties following adoption of national access to information legislation, which adheres to the international and regional standards elaborated in the model law. The importance of national legislation specifically provided for the right of access to information was recently buttressed by a decision of the High Court of Botswana issued on 26 of September 2023. In the case of News Company Pit Limited against Water Utilities Corporation, it was held that the High Court of Botswana has dismissed an application reviewing the water utility company refusal to release a report which researched water flow in the Gaborone Dam. The applicant submitted that it was irrational to withhold the report and that Section 12 of the Constitution on the right to freedom of expression includes the right to access to information. However, the court sided with the water utility company in finding that the report was intended for the benefit and aid of its operations and not for public consumption. The court concluded that Botswana doesn't have a Freedom of Information Act. Parliament is yet to enact such a law. Accordingly, I take this opportunity to once again call on state parties, which have not done so, to adopt access to information legislation in line with regional and international standards elaborated in the model law on access to information in Africa, and put mechanisms in place to ensure their effective implementation. Furthermore, an interesting initiative has emerged in 2019. A group of African countries recognized the need for a network focusing on access to information on the African country and created the African Network on Information Commissions, which is aimed at creating a platform for access to information on the African continent. So, in conclusion, I urge state parties to ensure that the right to access to information is guaranteed by law in accordance with the principles elaborated in the Declaration of Principles on Freedom of Expression and Access to Information and the Model Law on Access to Information in Africa. Ensure that access to information laws take precedence over any other laws which prohibit or restrict the disclosure of information. Ensure the employment of independent and impartial oversight mechanisms established by law mandated to monitor, promote, and protect the right of access to information. Ensure that adequate funding is provided to the oversight mechanisms to ensure their effective functioning. Ensure that consistent reporting is done on the legislative and other measures taken to give effect to the right of access to information in the periodic reports submitted in accordance with Article 62 of the African Charter, and to respond to letters of urgent appeal issued by the special mechanisms in order to provide clarification and information on the human rights issues raised by them. I urge NHRIs and NGOs to continue collaborating with the Commission and the Special Mechanism on Freedom of Expression and Access to Information to popularize the model law and other soft law instruments in accordance with Article 9 of the African Charter. I advocate them for the adoption of national legislation on access to information in states which have not yet done so. I thank you for your attention.
Thank you very much, Honorable Commissioner Grisha Topsisono. We now move on to the intervention from the states, national human rights institutions, and NGOs. We have one state that has registered, Tanzania. Richard Kiliganga, Assistant Director of Human Rights at the Ministry of Constitutional and Legal Affairs. You have 7 minutes.
Nashukuru mwenyekiti kwa kupata nafasi hii. Kwanza kabisa tunampongeza mtaalamu wa uhuru wa kujieleza na haki ya kupata taarifa kwa taarifa yake. Haki ya uhuru wa kujieleza na kupata taarifa imeainishwa katika ibara ya 17 ibara ndogo ya kwanza ya Katiba ya Jamhuri ya Muungano wa Tanzania ya mwaka 1977 na kifungu cha 18 cha Katiba ya Zanzibar ya mwaka 1984. Vile vile serikali imeridhia mikataba ya kimataifa na kikanda ikiwemo mkataba wa Afrika wa haki za binadamu na watu inayoainisha haki hii muhimu ambayo ni msingi wa demokrasia. Serikali imekuwa ikitekeleza wajibu huu wa katiba, kikanda na kimataifa wa kulinda haki ya kujieleza, kupata habari na kuwasiliana kupitia sera, sheria na kanuni, zikiwemo sheria ya haki ya kupata taarifa sura ya 149 na sheria ya huduma za habari. Haki hizi pia zimeelezwa katika sheria mbalimbali, na kwa upande wa Zanzibar ikiwemo sheria ya usajili, wakala, habari, magazeti na vitabu namba 5 ya mwaka 1988 na sheria ya Tume ya Utangazaji ya Zanzibar namba 7 ya mwaka 1997. Mheshimiwa Makamu Mwenyekiti, sheria ya huduma za habari ilifanywa mapitio ambapo serikali ilikaa na wadau wa habari na kuainisha maeneo ambayo wanadhani yafanyiwe marekebisho, na mwezi Juni mwaka 2023 Bunge la Jamhuri ya Muungano wa Tanzania limefanya mabadiliko ambapo baadhi ya manufaa ya mabadiliko ya sheria ya huduma za habari sura 229 ni: moja, kuifanya tasnia ya habari kutambulika rasmi kama taaluma; 2, kuimarisha uhuru kwa waandishi wa habari kufanya kazi kwa uhuru pasipo kusumbuliwa; 3, kuanzisha bodi ya ithibati; 4, kuanzisha baraza huru la habari; na 5, kuanzisha mfuko kwa ajili ya mafunzo kwa waandishi wa habari ambapo lengo ni kuboresha mazingira ya kazi ya waandishi wa habari. Mheshimiwa Makamu Mwenyekiti, katika kuhakikisha kwamba wananchi wananufaika na haki ya kupata taarifa na wana uhuru wa kujieleza, kuna zaidi ya redio 200, zaidi ya televisheni 60, zaidi ya televisheni mtandao yani online TV 390, blogs 73, magazeti na majarida zaidi ya 300. Kwa upande wa Zanzibar, jumla ya magazeti 3, vituo vya redio 27, vituo vya runinga 20, runinga za mitandaoni 44 zimeanzishwa na kusajiliwa, na hii serikali inajivunia kuwa na mafanikio, na jitihada hizi zinaonyesha namna serikali ilivyotoa fursa kwa wananchi na waandishi wa habari kupata taarifa mbalimbali za serikali na pia kuongeza kiwango cha uwajibikaji ndani ya serikali. Mheshimiwa Makamu Mwenyekiti, hivyo Jamhuri ya Muungano wa Tanzania itaendelea kushirikiana na wadau mbalimbali ili kuhakikisha wananchi wake wananufaika na haki ya kupata taarifa na uhuru wa kujieleza, na tutaendelea kushirikiana na wadau wa aina zote. Na kushukuru sana kwa kunisikiliza. Asanteni.
Thank you very much, distinguished delegate from Tanzania, and for keeping to the time also. We'll now move on to, we have 2 NGOs, Africa Freedom of Information Center, Observer Status 434, Gilbert Sendugwa.
Thank you very much, Chairperson, Honorable Chairperson, distinguished commissioners, state delegates, ladies and gentlemen. Africa Freedom of Information Center and its membership of 51 CSOs in 27 countries have the pleasure to commend the Special Rapporteur on Freedom of Expression and Access to Information in Africa for her leadership and excellent collaboration in the advancement of the right to information in Africa. The right to information is guaranteed under Article 9 of the African Charter on Human and People's Rights and is also recognized in 5 other African Union treaties, namely the African Charter on Democracy, Elections and Governance, African Union Convention on Preventing and Combating Corruption, the African Charter on the Values and Principles of Public Service Administration, the African Youth Charter, and the African Statistics Charter. We commend the Special Rapporteur on Freedom of Expression and Access to Information in Africa for her leadership in advocating for the ratification, domestication, and effective implementation of these treaties that are critical for Africa's integration and development agenda. In November 2019, the African Commission on Human and People's Rights adopted the revised Declaration on Principles of Freedom of Expression and Access to Information, where in Principle 26 states that the right to information shall be guaranteed by law. Earlier on, in 2015, all members of the United Nations, including all states parties to the African Charter on Human and People's Rights, adopted by consensus the Sustainable Development Goals Framework, which under Goal 1610 states that calls upon member states to ensure public access to information and protection of fundamental freedoms in accordance with national legislation and international agreements. Honorable Chairperson, distinguished commissioners, access to information is a fundamental human right essential for the realization of all human rights. It is also essential for the achievement of all SDG goals, as well as African Union Agenda 2063. Not long ago, the world was faced with the COVID-19 pandemic, where it was demonstrated that access to information can be the difference between life and death. Whether it is facilitating prevention of the spread of the disease, effective management of patients or building support, and effective reintegration of healed patients into their communities. Access to information is critical for entrenching democratic governance and a vaccine to military coups. In Africa today, we are witnessing the resurgence of military coups, many taking place shortly after elections, that are characterized by misinformation, disinformation, and lack of information, all of which discredit the processes, undermine public trust and legitimacy of outcomes of these elections, creating conditions which are quite often exploited by the militaries. Honorable Chairperson and Commissioners, it is deeply concerning that 42 years after the adoption of the African Charter on Human and People's Rights, 22 African countries are yet to adopt access to information laws and give effect to Article 9 of the Charter. These include Burundi, Cameroon, Central African Republic, Chad, Comoros, Democratic Republic of Congo, the Republic of Congo, Djibouti, Egypt, Equatorial Guinea, Eritrea, Eswatini, Gabon, Guinea-Bissau, Lesotho, Libya, Madagascar, Mali, Mauritius, Mauritania, Sahel Republic, Sao Tome and Principe, Senegal, and Somalia. Honorable Chairperson, distinguished commissioners, with only 7 years remaining for the SDG 2030 framework to elapse, we call upon the Commission on Human and People's Rights to do the following. Number one, through urgent letters of appeal and other channels, urge the states parties listed above to urgently adopt access to information laws, taking guidance from the model law on access to information that was adopted by this commission in 2013. Number two, undertake promotion of visits to these countries and encourage them to urgently adopt access to information laws. And number three, through the Commission's next report, request the heads of state summits of the African Union to adopt a resolution urging all its members to adopt respective national access to information laws within the next 12 months. Thank you for your kind attention.
Thank you very much. Thank you. We now call upon Matt for Peace, Development and Human Rights. Observer status number 528, Basan Esam, and I will urge you to keep to the time, please.
Okay. Thank you for giving me the floor. MAHAT expresses its deep concern about the contradiction of laws restricting freedom of expression in Somalia with the principles stipulated in the Interim Constitution and the African Charter on Human Rights and People's Rights. In 2020, amendments were made to the media law that ostensibly protected the rights of journalists, but also included vaguely worded provisions criminalizing the publications of false information and reports that conflicts with the national interest, and the law grants the Ministry of Information broad powers to regulate the media. From mid-September to October 2019, statistics showed 15 cases of online harassment and intimidation of journalists across the country. In addition to peaceful assembly is not respected in Somalia, in February 2021, the government banned demonstrations and police used live ammunition that month to disperse opposition protests against the postponement of presidential elections. Madam Commissioner, in this context, MAHAT urges the Somali government to conduct serious, prompt, effective, and impartial investigations into all cases of killings and violence against journalists and other media workers and bring those responsible to justice. It also recommends that the Special Rapporteur on Freedom of Expression in Africa put pressure on the Somali government to reform all provisions of the Penal Code that violates the right of freedom of expression, especially provisions related to criminal defamation and the spread of false news. Thank you.
Thank you very much. The last NGO is internationallawyers.org. Internationallawyers.org.
Yes. Thank you. Internationallawyers.org notes that the freedom of expression encompasses responsibilities as well as rights. Speech that is aimed at disparaging others' religion, for example, is not speech covered by freedom of religion and may in fact qualify as hate speech which provisions such as Article 20 of the International Covenant of Civil and Political Rights requires states prohibit. We raise this matter because of the increasing cases of speech being used to create differences between people of different religions, races, nationalities, and ethnicities. This has been a problem, especially in some countries in Europe, where speech directed at disparaging religious, national, and ethnic minorities has claimed the protection of human rights. We urge African countries to guard against such encroaches on the rights of others, and especially to be vigilant about speech that encourages hatred or encourages war. Such speech can and should be prohibited. We therefore urge the Special Reporter to consider both the responsibilities as well as the rights for which the freedom of expression provides in discussions with states. Thank you.
Very much. I'll now give Honorable Commissioner Grisha Thompson. So no, 1 minute, because we are way behind schedule. 1 minute to just wrap up.
Thank you, Vice Chair. We take note of the concerns of the NGOs, and we also take note of the progress made by Republic of Tanzania, but urge it to go ahead and make further progress on freedom of expression and access to information. Thank you.
Thank you very much, Honorable Commissioner. So we now got to the point where, who's that? Is it about an intervention? Okay. Is it Algeria, is it?
Oui, merci Madame la Vice-Présidente et désolé de vous interrompre. Bonjour à toutes et à tous. J'avais demandé la parole auparavant, mais je pense que le secrétariat n'a pas remarqué la demande de parole. Donc très brièvement, c'est pour d'abord remercier Madame la commissaire Topsy-Sonou pour la présentation de son rapport et très simplement et brièvement l'informer que l'Algérie a adopté une nouvelle loi organique relative à l'information. Donc la loi numéro 2314 du 27 août 2023. Et cette loi est conforme aux traités internationaux ratifiés par l'Algérie, à savoir la Charte africaine des droits de l'homme et des peuples, le Pacte international relatif aux droits civils et politiques, ainsi que la Charte arabe des droits de l'homme. Je vous remercie.
Thank you very much.
Yes, I'll take note of this, and we'll get in touch with the Republic of Algeria.
Yeah. And apologies for not getting the floor earlier on. Apologies for that. Yeah, we now reach the point where we can take a tea break. It's now for 30 minutes. It's now 10:42. Abiola, when do we get back?
12 minutes after 11.
12 minutes after 11, so that we can continue. Hopefully we'll be able to catch up on the lost time when we can come back. Thank you very much. See you.
I would like to indicate that tea and coffee will be served at the same venues where they were served yesterday and over the past few days. And also to indicate that in the afternoon we will be taking the statement